Welcome everyone to Fair Housing Coach's Coffee Break Quiz. I'm Heather Stone, Executive Editor of the Habitat Group and publisher of Fair Housing Coach. There we go. So it is April, Fair Housing Month, and this month HUD has marked Fair Housing Month by trying to educate the public about one aspect of the Fair Housing Act, its ban on discrimination in housing on the basis of sex. So our questions today will all focus on that topic. So our questions will work this way. I will launch a poll through Zoom, and you should see a pop-up window where you can answer the question. I'll read it. You can answer yes, no, true, or false. And then I will share the results with everyone. Could be 60% true, 40% false. And then our guest speaker will give us the correct answer and the explanation. And if you don't see the poll question pop up on your screen, it could be because you have an older computer. I know that sometimes Zoom doesn't work quite as well on older computers, or it could be a tech support issue. And unfortunately, I am the tech support person today, as well as your host. So I will ask you to bear with me if you do have problems seeing the poll questions. Keep tuned in because we will be repeating the questions and going through the answers. So hopefully you won't lose out too much on that. Also, if you look at the bottom of your screen, you might see a chat feature or a Q&A feature or a raise your hand feature. And again, as I have no tech support except for myself, I won't be answering any of those questions or responding to those features. But that doesn't mean that I don't want questions from you. So if you have questions after the webinar, please email me at hstone@thehabitatgroup.com. And it could be questions relating to today's webinar or any fair housing related questions you have. We'll try to address those questions in a future webinar or video or issue of Fair Housing Coach. So I'm going to introduce now Lynn Wilson, who's partner at Morris, Manning & Martin LLP. But before I even let her speak, I'm going to read a very quick legal disclaimer. This webinar offers general information only and is not intended as legal advice. Viewing the webinar does not create an attorney-client relationship with the speaker or the firm she represents. For legal advice on specific issues, please contact an experienced local attorney. Okay, now I'm going to introduce you to her properly. Hello, Lynn.
Hello.
Okay, let's get right to, I'm just going to check my notes really quick to make sure I covered everything. I think I did. Now I'm going to launch our first question, which is, only women can bring claims of sex discrimination under federal fair housing law. True or false? Give people a couple more seconds. Okay, only women can bring claims of sex discrimination under federal fair housing law. Is that true or false? I'm ending the poll and I'm sharing the results. Okay, 100% said false. Lynn, is that correct?
That is correct. Y'all are doing great so far. You might have thrown that first question though in there to get us warmed up. But yes, under the Fair Housing Act and interpretations by the courts and HUD, as it has evolved over the years, obviously, the use of the word sex refers to a person's gender, which by definition does include men and women.
Okay, very good. Let's go on to our second question, which is, you've heard rumors about a staff member pressuring female residents for dates in return for favors, such as a break on late rent. Although no one has complained, should you investigate? Yes or no? Okay, I will read the question one more time. You've heard rumors about a staff member pressuring female residents for dates in return for favors, such as a break on late rent. Although no one has complained, should you investigate? Yes or no? Okay, I will end the poll and share the results. Okay, looks like 94% said yes and 6% said no. Lynn, what's the correct answer?
The answer is yes, you should investigate. Because fair housing law considers sexual harassment as a form of discrimination on the basis of sex. And one form of harassment obviously occurs when a resident is pressured to accept unwelcome sexual advances in exchange for something related to the tenancy, whether it's maintenance, whether it's a break on rent, whatever that might be. And one other thing that is important to understand is that community owners and property managers can face significant liability in these cases, particularly if the harassment has been reported and not acted on. So it is very important to look into and investigate rumors, even in the absence of that tenant making a formal complaint.
Okay. Let's move on to question 3. I have to launch this, sorry. A prospect responded to an online ad and you invite her to come view available units. She arrives accompanied by her transgender woman partner. You only show them units at the far end of the complex. Is this a violation of the Fair Housing Act? Yes or no? Okay, I'll read that question one more time. A prospect responded to an online ad and you invite her to come view available units. She arrives accompanied by her transgender woman partner. You only show them units at the far end of the complex. Is this a violation of the Fair Housing Act? Yes or no? We'll end that poll. And the results. 94% said yes and 6% said no. Lynn, what do you say?
Yes, this is a violation of the Fair Housing Act. It is analogous in how we have looked in the past at steering in a broader category of some of the other protected classes, such as race, for example. But it is most definitely now, as the courts and HUD have broadened the scope of what is considered sex discrimination and the protected category under sex, it does very much so include this particular scenario. So it is important that property managers and owners recognize their obligations to ensure that all applicants, regardless of gender identity, sex, are treated equally and clearly shown the same apartments, the same units, and have access to the same areas of the complex.
Okay, very good. Our next question is, a transgender woman is asked by the owner of the apartment building to not dress in women's clothing in the common areas of the property. Could the tenant file a complaint asserting a violation of the Fair Housing Act? Yes or no? I'll read that one more time. A transgender woman is asked by the owner of the apartment building to not dress in women's clothing in the common areas of the property. Could the tenant file a complaint asserting a violation of the Fair Housing Act? Yes or no? And I'll end that poll and share the results. 100% say yes. Lynn, are they correct?
They are correct. Obviously, I'm speaking to people who know this area of property management and the law, and it's frankly awesome to me that the answer is so resoundingly 100%, because yes, this is clearly a violation of fair housing, because a person who identifies as LGBTQ and who experienced discrimination on the basis of their sex And in this case, their gender identity or sexual orientation does have standing to file a complaint.
Now, let's say the tenant wasn't the person, this was a friend of the tenant, a visitor. In that case, could the tenant still file a complaint based on the owner's telling the visitor to dress a certain way?
Yes, in the sense that the tenant's ability to exercise enjoyment of their living accommodations has been impacted, yes.
Okay. We'll move on to our fifth and final question. A lesbian tenant is being harassed by her neighbor. The affected tenant has not reported the harassment to management. Can the property manager and/or owner of the apartment building be held liable under the Fair Housing Act? Yes or no? I'll read that one more time. A lesbian tenant is being harassed by her neighbor. The affected tenant has not reported the harassment to management. Can the property manager and/or owner of the apartment building be held liable under the Fair Housing Act? Yes or no? And I will close the poll. And the results are 61% say yes and 39% say no. Okay, Lynn, what's the correct answer?
The answer is yes, but the responses by the people participating today are, I think, telling, because this is a much closer and more difficult question, not necessarily because the tenant is a lesbian, but because the question is really whether the fact that the tenant has not reported it at all constitutes some sort of immunity or lack of liability, not immunity, lack of liability on the part of the property management company or the owner. And although today there's not a case that is completely on point with this particular lesbian tenant, there is a recent case, Francis v. Kings Park Manor, in the U.S. Circuit Court of the Court of Appeals for the Second Circuit, that is very analogous, although it was a race discrimination case. And in that instance, the U.S. Court of Appeals held yes, the property management and the owner was liable. So I would argue that given that, it's probably only a matter of time before there is case law that clearly makes it analogous to this situation.
Okay, very good. I think I will end those questions. Well, thank you very much, Lynn, for being our guest speaker today. And thank you everyone for participating. And please visit us at fairhousingcoach.com and be safe and be well. Thank you very much.